mundo y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de Alex Murdaugh. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination true crime cases. Listen. Okay, you guys. So at this point, we have covered a number of different videos on Alex Murdaugh and the documents that were filed into his case, basically for the purposes of getting his convictions overturned, which worked, right? So we know it worked now. But anyways, long story short, in one of the last videos, we talked about the brief that Murdaugh's attorneys filed on his behalf after the trial court refused to overturn his conviction, stating that Miss Hill's statements weren't really all that harmful. Do you remember that? Okay, cool. So now we're going to talk about the state's response to that brief. Go ahead and just buckle yourselves in. Let's go ahead and get into it. Okay, so unlike the brief number of arguments that we had in the previous motion that was filed by Alexander Murdaugh or his attorneys, here the state articulates themselves or makes 9 main arguments. So let's go ahead and get it into it. As you guys can see here, the state of South Carolina and the Supreme Court, the state is considered the respondent because they're responding to the appellant, who is Richard Alexander Murdaugh. Argument 1 and 2. The jury convicted appellant because he was obviously guilty, not because 3 jurors heard Becky Hill's, quote, foolish and fleeting comments about his upcoming testimony. 3. By failing to appeal all the grounds upon which the trial judge's ruling admitted the financial crime evidence was based, appellant waived his objection to that evidence. Furthermore, the trial judge did not abuse his broad discretion by admitting the financial crime evidence pursuant to Rules 404B and 403. Okay, you guys, so I'm going to stop right here and give you guys my opinions on arguments 1, 2, and 3. So as we know now, arguments 1 and 2 hold the most weight. And those are the arguments with relation to Ms. Hill and her maliciousness and her callousness and her selfishness and all of her nesses, okay? These are the arguments as it relates to her. The third argument is about how the trial court did not improperly admit the evidence of the defendants or the appellants in this case, financial crimes as 404B and 403 evidence. Okay. Now, as I said in my last video, I felt like that kind of sounded like whining on behalf of Murdaugh's attorneys to even bring it up. And yeah, so I'm interested to see what the state is going to say in response to that, but I'm going to go ahead and already give them the upper hand. Anyways, what I'm saying is this. Arguments 1 and 2 bode better for Alex Murdaugh. This third argument bodes better for the state. Argument 4. Appellant is not entitled to any relief considering the trial judge not only did not abuse his discretion by finding that defense counsel had opened the door to redirect questions to test Will Loving's knowledge for assertions during cross-examination regarding appellant's general character and motive for killing his wife and son, but also finding, as an alternative basis for overruling the objection, that defense counsel failed to assert any legal ground for the objection, an alternative ruling appellant does not challenge on appeal. 5. The trial judge admitted evidence of appellant's financial crimes under res gestae and alternatively under Rule 404B during the state's case in chief after a detailed in-camera review and consideration of the parties' arguments. Appellant's later testimony admitted the financial crimes merely confirmed the already evident and uncontested, clear and convincing finding under the alternative Rule 404B analysis and is harmlessly cumulative to the similar admissions presented through witnesses Crosby and Wilson, and a confession of judgment. Appellant's attempt to assert a non-waiver of the financial crime issue in this appeal, contesting only the Rule 404B ruling, is of no consequence. Okay, let me stop right there and explain to you guys what they mean by that, okay? So we already talked about 404B and what 404B was, but as a reminder, because I'm here to be the broken record you guys need me to be, 404B is evidence of prior bad acts, right? And typically when a party seeks to introduce evidence of a defendant's prior bad acts, they go to a hearing and the court will allow or disallow the evidence to be admitted at the trial after the court concludes such evidence to be relevant at a hearing. Does that make sense? Does that make sense? Res gestae is this. I'm getting tired. Sorry. Normally I just cut this stuff out, but I'm trying to give you guys like more of my real personality. So I might just leave it in, but I don't even know. I might just be talking to myself. But anyway, sorry, let's carry on. Res gestae evidence is this. Basically, it's considered as part of the common scheme or plan of the crime in question. So it's not 404B. And I know that is so confusing. They're kind of intricately intertwined in a little bit of a way, but let me just go ahead and explain what I mean to you. So like, for example, the prosecution here by bringing up res gestae is saying, we're not trying to introduce evidence of prior bad acts. We are showing evidence that is connected to this bad act. I'm going to try to give you guys a better example because I know it's really confusing to follow. Okay, let's say a 404B evidence in a domestic violence case is the fact that this specific defendant has previously abused other women, but he has not been convicted of that abuse. So there's no conviction to enter, but instead you need to go to hearing to see if that evidence is admissible at trial to prove a motive or a plan or a scheme or a common occurrence of by which he did it. Does that make sense? I hope. You guys, please let me know if it doesn't make sense down below because I'm really trying. But res gestae could be this. The defendant went to a gun store and stole a gun. And then an hour or so later, or a day or two later, then robbed a bank with the gun, right? And so defense would say that admission of the evidence that he went to the gun store and robbed the gun is 404B because it's a prior bad act. But the prosecution would argue, no. It's res gestae because it's part of the same similar scheme. He robbed the gun from the gun store, and then went and robbed the bank or whatever I said he robbed. Does that make sense? I hope this is making sense because it's making sense to me. It makes sense in my head, and I hope I'm explaining it well. But let me know down below, okay? Let's carry on. 6, the trial judge did not abuse his discretion in overruling appellant's objection to the state's cross-examination of appellant on his failure to correct what he admitted during his own trial testimony had been multiple false statements to law enforcement, family, and friends indicating that he had not been at the kennel minutes before the double murder occurred. Not only had various witnesses already testified that appellant had given the same false story that he had not been at the kennels, the defense had throughout the trial elicited testimony suggesting that appellant had fully cooperated with law enforcement, and in admitting his false statement in his testimony, appellant asserted that he had been denied the opportunity to correct his statements by prosecution. As such, appellant invited the cross-examination. 7, appellant waived his issue with the state's rebuttal expert testimony about an out-of-court experiment involving an iPhone by failing to raise a timely, contemporaneous objection when the testimony was first admitted, and by failing to appeal the trial judge's finding defense counsel objection was late. Furthermore, the trial judge did not abuse his discretion by permitting the state's rebuttal expert to testify about the results of the out-of-court experiment he conducted in response to an in-court experiment performed by a similarly qualified defense expert. 8, the trial court did not abuse its discretion by admitting into evidence 1, opinion evidence from a qualified firearms expert after application of long-accepted analysis methodology. 2, guns seized from appellant and or home consistent in type and caliber of the weapon used in the murders. And 3, a rain jacket seized from appellant's parents' home connected to appellant, which also tested positive for gunshot residue, or GSR. The trial court applied the appropriate test for admissibility, and its findings of fact for the purpose of admissibility are well supported in the record. Appellant's argument to the contrary fails. And 9, appellant has abandoned his cumulative error issue as he failed to offer any argument on the issue in the briefing. Even so, such an issue would be procedurally barred as appellant did not preserve an argument that a specific combination of purported errors otherwise insignificant when viewed alone denied him a fair trial. Okay, before we get into anything else, did I already tell you guys that this brief is 182 pages? And if I didn't, I meant to tell you that this brief is 182 pages. And we're not going to go through all of that because I'm just not going to. But let's go ahead and read some of the parts and just give you my opinions and my thoughts on the arguments that were made here. Argument 1 and 2. The jury convicted appellant because he was obviously guilty, not because 3 jurors heard Becky Hill's foolish and fleeting comments about his upcoming testimony. Becky Hill's improper comments did not affect the outcome of this case. Only 2 jurors heard her unsolicited remarks to watch appellant's body language, and only 1 juror heard her comment that the day of appellant's testimony was an important or epic day. The records support Justice Toll's finding that the verdict was solely the product of the jurors' honest deliberations and reflected the overwhelming evidence of appellant's guilt. In this section, the state will first address the proper test for analyzing claims of outside influence. Appellant argues at length that Justice Toll should have presumed he was prejudiced. The state will respond to the argument, but the discussion is largely academic because Justice Toll found that even if a presumption of prejudice applied, the state rebutted it. The state will also address appellant's creative argument that the presumption is irrebuttable in this case. The state will then show that Justice Toll's findings are supported by the record. Justice Toll's inquiry may have exceeded the scope of Rule 606B, South Carolina Rules of Evidence, but this does not affect the validity of her findings. Justice Toll properly applied the factors laid out in State v. Kelly and correctly concluded Hill's comments did not affect the deliberation. This court should affirm. I'm going to just stop right there because I always think it's funny because lawyers be battling for real. Okay. They be battling for real. And some of the things that I be reading in briefs are kind of funny to me. Like, for example, the creative argument. that was a funny way of being like, this argument they done concocted. It was so creative. It ain't based in nothing but their feelings, basically is what they're saying. And I don't know. You guys might not find it funny, but I find it funny whenever I'm reading these briefs and I see the insults that are hurled back and forth amongst one another in a most professional and lawyerly way. Let's carry on. Justice Toll found that even if a presumption of prejudice applied, the state rebutted it. The record supports this finding. Regardless of any presumption, the ultimate question is whether Hill's comments affected the jury deliberations. As Justice Toll found, they did not. The record supports Justice Toll's finding that the appellant was not prejudiced. Of the 12 jurors who voted to convict, 9 testified they did not hear Hill make any comments about the case. Thus, the question whether Hill's comments influenced their verdict was superfluous and meaningless to 9 jurors. Juror X testified Hill said the day of appellant's testimony was an epic or important day. Only jurors Z and P testified they heard Hill say comments to the effect that they should watch appellant or his body language during his testimony. 11 jurors testified Hill's comments had no effect on their verdict. Hill's comments were inappropriate, but due process does not require a new trial every time a juror has been placed in a potentially compromising situation. While Hill should have not made any comments to the jury about the case, her characterization of the day of appellant's testimony as epic shows she could not contain her excitement when she learned appellant would testify. It does not show a nefarious plot to influence the jurors. Further, it was obvious that appellant's testimony was important. I'm going to just stop right there and tell you guys how I could not disagree with this argument anymore, right? Because I don't remember which brief we were reading that said it, but a defendant is entitled to a fair and impartial jury, not an unfair and impartial jury of 9 people who didn't overhear a statement that was made by a person who shouldn't have made the statement to begin with. What are we on? Like, what are you talking about? And on top of that, I think the fact that they ended this specific segment or this specific paragraph by saying, further, it was obvious that appellant's testimony was important is ridiculous. Because what did we talk about? The defendant has a right not to testify. So saying that his testimony was important was obvious is crazy because he didn't have to testify at all. So I didn't like that they did that. But, you know, I'm not really thinking that this argument really swayed anyone because as we know now, he was granted a new trial. But anyways, let's go ahead and carry on. Appellant contends the trial judge reversibly erred by failing to exclude evidence of his financial crimes pursuant to Rule 404B and Rule 403 of the South Carolina Rules of Evidence. Although recognizing the evidence was admitted for the purpose of establishing his motive, appellant nevertheless maintains the state's fabricated motive theory was illogical, implausible, and unsupported by the evidence. Therefore, he asserts the financial crime evidence should have been found inadmissible pursuant to Rule 404B. Furthermore, appellant maintains the unfair prejudicial effect of the evidence substantially outweighed any probative value it may have had, and thus it should have been excluded pursuant to Rule 403. there are multiple problems with appellant's arguments on appeal. First, the trial court additionally admitted the evidence as res gestae evidence, but appellant failed to challenge that basis for admission on appeal. As a result, he waived his challenge to the evidence. Second, notwithstanding appellant's failure to appeal all grounds upon which the trial judge's ruling was based, the trial judge did not abuse his discretion by admitting the financial crime evidence as evidence of motive because he correctly followed all steps of the applicable analysis and took appropriate steps to ensure appellant would be unfairly prejudiced by the evidence admissions. The trial judge's ruling should be affirmed. Okay, you guys, let me go ahead and stop and explain this segment to you right here. And I hope you guys can hear how hoarse my voice is. And that's because I've been recording for you all day. But basically what they're saying is, because Alex did not appeal all the bases by which the financial crimes evidence came in, he waives his right to appeal that segment. Does that make sense? So if I'm remembering correctly, what he appealed was that it came in and it was improper under 404B and 403. But he didn't say that it was improper as to res gestae. And what they're saying is, because he didn't include that, he waived the right to argue that the evidence was improperly admitted. Does that make sense? Okay, let's go ahead and carry on. The trial judge admitted evidence of appellant's financial crimes under res gestae and alternatively under Rule 404B during the state's case in chief after a detailed in-camera review and consideration of the parties' arguments. Appellant's later testimony admitting the financial crimes merely confirmed the already evident and uncontested, clear and convincing finding under the alternative Rule 404B analysis and is harmlessly cumulative to the similar admissions presented through witnesses Crosby and Wilson and a confession of judgment. Appellant's attempt to assert a non-waiver of the financial crime issue in this appeal contesting only the Rule 404B ruling is of no consequence. So again, they're just basically saying what I told you they're saying, right? So because he didn't argue that all of the bases by which the financial crime evidence came in were improper, he waives his right to talk about it at all, is basically what they're saying, right? Now, did I know that there was an in-camera review? No, I didn't. Okay. No, I didn't. So that's really exciting to learn because now that there's an in-camera review, I know that the court did not improperly admit this evidence because it held all the proper procedures and steps before this evidence was introduced. Anyways, in the beginning of this video, I told you guys that the brief was extraordinarily long at 182 pages. And I'm not going to continue reading because my throat hurts. Okay. We just won't cap it like that. But I want you guys to let me know anything it is you want to let me know about this video down below. Again, before I let you guys go, I'm going to do this in every single video. If you liked what I said or liked what I had to say, can you please let me know? If there's more parts of this brief that you want me to analyze and provide my opinions on, can you please let me know? Can you let me know anything it is you want to let me know down below? And subscribe. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.